Thank you, Rob. So next up we've got Andrew Cormack, who's here to talk about GDPR. Andrew's the Chief Regulatory Advisor at Janet. So I know Andrew's got quite a lot he wants to say, so I'll let him get on with it.
Do I have to do one click for the slides? Yes, there we are. I was interested, the title of this conference is Everything Changes. And I think in GDPR, General Data Protection Regulation, I don't think that's true. If you're doing the current Data Protection Act, Data Protection Directive, right, more or less, all of that, nearly all of that, I think will carry over. The main change, what does change, is, and this is my sort of very short elevator pitch, under the Data Protection Directive, the current 95 law, the question to think about is what personal data are we processing? Under the regulation, the question to think about is why are we processing that data? And that, I think, is the change that drives almost everything else. What doing a lot of work. I think I'm pretty much full-time at the moment on trying to work out how to do this within GISC. So what I'm proposing to talk about is, I think, 4 ideas that we're using internally to make that switch. And I hope they're all useful. So, start with, this is the Information Commissioner a while back did a document on 12 steps to GDPR, which has, to me, a slightly strange sequence. So I thought, well, that doesn't really make sense. And sorry to previous speaker, this looks a little like a waterfall diagram. But there are dependencies. So I took the ICO 12 steps, worked out which depended on which others, and came up with this. So you start off awareness, data protection by design, and impact assessments, 2 long processes that will take you a long time to get in place. So get on with those. The next one, which everything else depends on, and if you want more detail of this, I did a talk yesterday at our GISC event, which I hope will be up online, so have a look at that, but is an information lifecycle audit. So this is the change. This is why are we processing data, not what data are we processing. From that, you derive breach notification process, legal basis for processing. From the legal basis comes what needs to be in privacy notices, what rights individuals have, data subjects, and if your legal basis turns out to be consent, there is some stuff around that. There are, I'm a mathematician, I make that 8 bars, and you're saying there are 12 steps. 2 of them are doubled up, so individual rights and subject access, the ICO has as 2, and consent and children, the ICO has 2. The other 2 are appoint a data protection officer and work out what country you're in. So today, looking mostly at those 4 in the middle. Information life cycles. This is my simple data protection information life cycle. And the questions that we need to be asking, because the answers to those questions drive everything else. So collecting data, why are we collecting data? Yeah, okay. Can I both see the slides down here and be heard by the microphone? Maybe. Why are we collecting data? What data do we need for that? Do we actually need all the data that we're collecting? Big GDPR question. Data minimization. Who do we get it from? Are we getting it from the data subject? Are we getting it from somebody else? Please register your colleague for the GISC conference. That makes life a little interesting. Or are we actually getting it not direct from any individual at all? We're either getting it from another process or we're observing it. And again, there's even less of an opportunity to actually inform people what's going on. So those get slightly more tricky, direct and indirect. We've got the data, let's process it. Again, why? How are we processing it? Where? Physically, sadly, in this wonderful 21st century digital world, the GDPR still believes that physical location is important in terms of regulation, if nothing else. But also, are we processing in a state-of-the-art data center with power backup and everything, or are we processing on a machine under a desk or a laptop that might get stolen? Big difference. How do we keep it secure? Again, different answers. Is it in a big concrete box? Good. Is it on a laptop? Maybe good. Is your laptop fully encrypted? Is the user, I will be working for 3 hours tonight on the train, does the user know what to do on the train, and most important, what not to do on the train? Now, technology can't help if your users, there was a tweet from somebody coming to our conference yesterday, if your user reads out their password on their mobile phone. All the technology in the world cannot help that. And it's really noisy on trains, so you have to speak very slowly and loudly and clearly when you're giving your password. Question I would put in here, because I think it fits quite nicely, is what happens if there's a security breach? If you know what information you're processing and why, you should be able to make a reasonable stab at how damaging this is going to be if the information is taken away or lost, in the sense of destroyed. Security breaches are another separate thing on the ICO chart, but this is where I put them in because it feels like the natural place to understand them. And then dispose, and this seems to be quite a hard one. Oh, we might need it one day. Wrong. When are data no longer needed? There's no if in that. There will always be a time or an event which says this data is no longer needed. Work out what that is. Then, how are we going to dispose of it? Do we delete it? Good. Job done. Do we aggregate, collecting up numbers of attendees at the UCISA conference this year? Maybe you've got the list of people who were here last year. I hope you haven't got too many complete delegate lists going back. At some point, numbers of people from institutions becomes the useful, relevant, non-personal, hooray, thing. Anonymize is tricky because the ICO is increasingly saying those wretched researchers keep coming up with new ways of de-anonymizing data. And the more data we put out in public, through social networks and things like that, the harder it is to keep anonymized data anonymized. The Netflix discovered this the hard way. They published a list of films and films that individual number one borrowed this film that week, this film that week, this film that week. It's anonymized, isn't it? Except the researchers discovered they could go to IMDb and look and see who had posted reviews of those films that week. And very quickly, if you were active in posting reviews and giving scores, you de-anonymize. A couple of optional stages which will come up sometimes in this. Share, by which I mean situations where you've got continuing responsibility. You're reusing the information internally for a different purpose, or you're sharing with some kind of partner organization. But you are still responsible for that processing at some level. Internally, the best way I've found to fit this into the model is say, okay, start another life cycle. And this is one of those life cycles where the collect stage is, oh, we got it from another process, not we got it from the individual. External, you need to work out how to share responsibilities, how to assign responsibilities between the two or more parties, and that probably needs some form of agreement, possibly up to a contract. Distinguish from disclose, which is where you manage to give away data and your responsibility ends, and that one really only applies when the law says you can give away this data in these circumstances and not be responsible for what happens afterwards. Classic case of that, current Data Protection Act section 29 of handing data to law enforcement where it's necessary for a criminal investigation. So that's my information life cycle. Why came up quite a lot. Why are we collecting? Why are we processing? That gives you, I think, the legal basis, which feels like, from once you've got this, everything else is a lot of, but handle cranking, I think. My list of legal bases is pretty much, I think, in the order in which you should consider them. And I've got a rule of thumb question for, is this likely to be the right basis for this setup? So, Necessary for contract, is there an agreement somewhere? If there is an agreement and the processing is necessary for it, we're done. Necessary for a legal obligation. Is there a law that says you must disclose to HMRC how much you pay your employees, for example? Yes, there's a law. We do what the law tells us to. We're done. Necessary for vital interest is a life at risk. And this pretty much is life. Maybe serious injury if you've got hazardous workplaces and you want to check, keep a record of who goes in and, most important, who comes back out again. Might figure in that one. Necessary for public interest. Almost entirely undocumented what this one means. It's been in the law for more than 20 years. I've not found any example of it being used. There was a hint about a decade ago where the European regulators said, well, necessary for public interest is what's used when you want to help somebody who's got a legal obligation. So tax office has a responsibility, or have a responsibility, somebody's got a responsibility for investigating benefit fraud. I've got some evidence that might suggest that a benefit fraud is taking place. There's no legal obligation on me to disclose it, but it might be in the public interest for me to do so. I say I've seen no discussion of that since that one little comment very early in the discussion of GDPR. But there should somewhere be a law that doesn't require me to do it, but at least describes it and requires somebody else to. And necessary for legitimate interest, where I was trying to get a question into one line. If something is surprising to the individual, then legitimate interest probably isn't the right basis. If you come to our website, probably next slide, come to our website, are you surprised that we keep logs in order to investigate the security of our website? Good. Because we claim legitimate interest for that one. And finally, and I do stress the finally, if none of the above work, the one that doesn't have necessary in front of it, which I'm increasingly thinking actually means it has unnecessary in front of it, because if something is necessary, I don't think somebody can give free consent. Certainly not in an employer-employee situation, challenging in a university student situation, I think. So my question on consent is this really optional for both of us? So, or as I suggested somebody yesterday who promptly retweeted it, can I lie and it doesn't matter? So, my registration form, I told the truth. Would it break the conference if I had given my name as Harry Potter? Don't think so. Might find it tricky to reference my bio, but, or you might have got a much more interesting introduction. Yeah. Some things there's more than one basis. I've mentioned if you want to subscribe to updates to our website, okay? We need an email address. If you want us to send you email notifications, we need an email address necessary for the agreement. Can't provide the service without it. Legitimate interest, I've said, we do get, I take it as a badge of honor, I occasionally get comment spam on my blog. People must think it's a worthwhile place to put adverts. Fortunately, they usually hit our filters and it doesn't happen. So we can't secure the service without doing this process. Legitimate interest, things like IP address, where are you coming from, how frequently are you trying to subscribe, stuff like that. And a consent one. If you want to put a picture on your personal profile page on GIST Community, feel free. If you want to put a picture of your cat, feel free. Consent. There is a bit of a mess, that's putting it politely, around what the GDPR says about public authorities and what the Freedom of Information Act says about public authorities. It's a little while since I was a law student, but I can see no justification for saying those two terms have to mean the same. However, the Information Commissioner has said that they do. What the GDPR says is that public authorities can't use legitimate interests, actually, or consent, for their tasks. And those last three words are almost always missed in this discussion. It then says those tasks must be defined by law. Okay. And David Erdos pointed me at a case way back in 1989 where the European Court of Justice looked at bodies that are assigned special powers by law and to process personal data in a non-standard way. And that seems very much what the GDPR is thinking about. But very clear from the GDPR, if you're not doing your task, you're not restricted in which bases you can use. And if your task must be defined by law to be a task, if you're not doing something that's defined by law, I don't think there's any restriction. And the only, I'd be interested to hear afterwards if anybody knows of any, the only special power that I can come up with that universities have is relating to visa sponsorship. So I think there probably is a justification for applying this there. The Data Protection Bill in Parliament right now says public authority means what it means in the Freedom of Information Act. Oh dear. The ICO has now stopped talking about public authorities and is talking about hybrid authorities, which is yet another existing term taken from human rights law, so another relevant section. But certainly saying, recognising that there will be some things that universities do that are not covered by the prohibition. And then the ICO says, well, if it is a task, you can use public interest. Okay. Which is really weird because the ICO is supposed to be protecting data protection rights. Public interest is exactly the same as legitimate interest, except you don't need to take the individual's rights into account. So the ICO is actually arguing for a reduction in the protection of data subjects. We've pointed that out. So my suggestion is if legitimate interest, on my rule of thumb test, looks like the right basis, use it. If the ICO complains and says, no, that is one of your tasks, you should not be using legitimate interests, go through, do a cut and paste, delete the word legitimate, and replace it with public. And if you want to delete your test of rights and freedoms, you can. Please don't, because I'm a data subject of at least 3 universities. Service categories. We were trying within GISC. We've got 120 services. We've got, I think, 200 days now till the 25th of June, including weekends. And I don't respond to pizza, I'm afraid. Certainly not Coke. So we were trying to work out some prioritisation. Which things do we really, really need to be sure that we've covered by next May? And I came up with 4 categories. First one is based on the relationship between us and the individual. First one, we have a direct interaction with the user. So it's very clear from the nature of the relationship how long the relationship's going to last. Ask a question to the GISC help desk. We will find an answer to the question, we will send it back to you, and we're done. The task has finished. Originally, this was just about prioritisation, but it then struck me that this also gives us quite a lot of hints about which forms of communication, which forms of protection we should be using, or are most likely to be relevant. This one, privacy notice. We will tell you what we're going to do. I hope it's blindingly obvious. Terms and conditions, do we need a contract to support a query to the help desk? I don't think so. There's not really anybody to contract with anyway. Legal basis test, well, ideally, but actually the legal basis is almost always going to be doing what you asked us to, which I reckon is, as long as we're doing data minimization, is necessary for contract. Do we need a data protection impact assessment? Nah, not for these, unless somebody comes up with a really scary question. Slightly more complicated, long-term relationship, but still direct. So this is subscribing to a service, being the site contact for something. At the time we enter into the relationship, we don't know when it will end. But we know what will cause it to end. So this is back to my, there is no such thing as indefinite retention. When we hear that you are no longer working for the organization, our processing of your data as the contact for that organization should stop. Example here, the site contact for Eduroam, the person that we contact when Eduroam isn't working. We'll get to the next one. Here, privacy notice, again, yes. Terms and conditions, perhaps. Depending on what the relationship is, we may want to have terms and conditions either with the individual or with their organisation. Legal basis test, this one feels to me a little tempting. We've got this data, can we send them emails? Can we contact them? Can we phone them? Can we do stuff like that? So I'd like to have the legal basis test to set the parameters to the individual, to explain to the individual, this is what we're going to do with your data. Again, impact assessment, I very much doubt it. Okay, a little more complicated. Eduroam user, who may not actually know when they walk into the Mercure across the road that the reason that their laptop is getting connection is because we are processing authentication requests. They may just go, hey, Wi-Fi, and we hope they do. Privacy notice, yes, we will describe what we do. Terms and conditions, yes, because here the individual has a relationship with the university, not with GISC. So we need to agree with the university what the relationship is, what the relative responsibilities are. So there will be terms and conditions on these. Most services there are already. And we're going through them to try and make sure they have everything GDPR says they should. Legal basis test, again, yes, I think so. DPIA, possibly. Here I can imagine there might be relationships where the processing would get into the sort of area where the Article 29 Working Party have said you need to do a data protection impact assessment. They have a list of 9 characteristics of processing. If you tick any 2, then you probably need a DPIA. And I can imagine that services of this kind which would tick 2 boxes. Number 4, really scary, the user may not be aware of the service's existence at all. So we do a lot of work to protect your networks and ours from denial of service attacks. Do your users know about that? Probably not. That's scary, because how do we display the privacy notice? You know, your users would love it if every time they connected to Janet, their screen came up with a big privacy notice saying, did you know we do DDoS? We'll have a privacy notice, but I don't think there's a way to push this at people. So the main way we're protecting stuff here, terms and conditions, maybe depends if there's an actual party to have a contract with. In the case of DDoS for the Janet network, I suspect there isn't. Legal basis test, absolutely. Here it's probably legitimate interests, so we need to make sure that we're doing the balancing test of rights, our interest against the individual's rights. And we've come up with 2 on these, and both of them do need a DPIA. So, and I'm expecting that anything at this level. Actually, the DPIA is our main protection for demonstrating that we have taken appropriate care in the way we design the service. Privacy notices, finally. Where do I have to point that way? Big problem on privacy notices because with 200 days to go, we don't even have a draft of what the ICO thinks a privacy notice should look like. I'm not happy. I will be glaring out of the window as I go through Wilmslow this evening. Sorry, we need to implement stuff now. So what we've done in the past couple of weeks, both to try and get the information that needs to be there and to future-proof ourselves in case the ICO comes up with something off the wall. We have a single master privacy notice for all GISC services. 1 copy, 1 website, 1 thing to modify if the ICO needs us to. What's on there is what the GDPR says needs to be on there. So data retention, how long we keep data, or in what circumstances we will stop keeping data. Any transfers to other organisations, exports and how we protect them, any exports from the European Economic Area and how we protect those, how we keep stuff secure, and how you can exercise your rights, because those are common to all services. They're divided up. There are 3, well, one of them's 2 paragraphs, the others are 1 paragraph each. Remember my slide about legal bases? The first 3 of these may look familiar, I hope. It's written in user-friendly speak, which I confess I found rather hard as a mathematician and graduate in maths and law. Writing user-friendly doesn't come naturally. But, service you've requested. You've asked us to do something. This is how we protect the data while we're doing it. Identify problems or improvement. Anybody getting feelings of this might be legitimate interest? It is. I'm hoping the lawyers can do the translation. I'm not expecting ordinary people to do the translation back the other way. You asked us to consent in legal terms. And the one that isn't actually a legal basis is we're operating a service that's provided to you by a third party. So things like the Learning Analytics Service, we provide it, universities make it available to their students. So most of the responsibilities there fall on the university. And then for each service, there is what can be 2 lines. It states which of those 4 purposes apply, and it provides a link to the master notice. That's the minimum. And that, I hope, is what all of the transactional ones will do. So I hope I've covered all of the majority of our services because they're transactional. We may add, individual services may add who the recipients of any transfers are, what countries any exports take place to. I struggled with how to get directories into the export model, and then I decided I couldn't, so directories are listed separately. Now, if registering for your conference results in you appearing on a public list of those attending the conference, it's a separate entity. Is it covered by our ISO 27001? Have we done a DPIA? And there are various other things that the level 3 and level 4 services I might talk about. I prefer not to start doing those on the bulk, large numbers of level 1s and level 2s. And again, there's 3 options: transaction-based, relationship-based, and consent-based. I was hoping we didn't do anything by consent, but we do. We do occasional surveys, and there I think consent is the only basis. If you want to look at that, it's up on the website there. We're gradually rolling out the per service stuff, so watch out for those turning up. And that's me done.
Nearly.